jury just came back with a verdict in your favor. What does it mean when the defense asks the judge to throw out your verdict, claiming that it's against the weight of the evidence? You want to know what this means? Come join me for this walk as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, on this walk today, I'm going to go through with you and explain to you exactly what happens after you get a verdict in your favor. So let's say this is a medical malpractice case and you sued your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. Your doctor denied any of your claims, which means that your case went the distance and you went through the litigation process, and now it took you 2 years to actually get to trial. Okay, fine. So now, after 2 years, your case finally comes up for trial, and now you put on all of your witnesses, you put on all of your experts, all of the testimony needed to show that you are slightly more likely right than wrong, that what you are claiming is true. Now, at the same time, the defense put on whatever evidence and testimony they felt were necessary in order to defend your case, to try and show the jury that they did absolutely nothing wrong, and that whatever the doctor did or didn't do did not cause or contribute to your injuries. And then, of course, to go ahead and show the jury that, hey, your injuries really aren't as bad as you claim. That's what happens during the course of a medical malpractice trial. So now, what happens then? So now the jury actually goes ahead and reaches a verdict. After the judge has given the jury legal instructions about the law in your particular case in New York, the jury is asked to evaluate certain questions. And they have to answer certain questions in order to reach a verdict. The answers to their questions actually represent the verdict. It's not like they come back with an answer and say, Judge, we have a decision. No, it's broken down into specific questions. And typically those questions are, listen, was the doctor negligent? Did he violate the basic standards of medical care? Yes or no? If the answer is no, your case is over, and that's the end of it. If, however, the answer is yes, now the jury has to go ahead and answer the next question, which is, was the doctor's carelessness a cause of your injury? It doesn't have to be the cause, only a cause. If the answer is no, then there's no connection between the wrongdoing and your injury. And what does that mean? It means your case is out and you get nothing. But if, however, the jury determines that yes, there is a connection between the carelessness and the wrongdoing, then guess what? Now the jury is required to go on to the next step. And what's that? They now have to evaluate damages, how much money you are to receive as a result of the doctor's carelessness. So now after the trial, after the judge gives the jury instructions, the jury comes back with a verdict, and the verdict is in your favor, which means the jury believes that you are slightly more likely right than wrong, and now they have compensated you. They have given you money for all of the harms and losses and damages that you incurred because of the doctor's carelessness. So now one of the first things that's going to happen is the defense attorney is going to jump up out of his seat and he's going to ask the judge to throw your case out. Why? Because he's going to claim that the verdict is against the weight of the evidence. Now what does that mean, against the weight of the evidence? The defense lawyer is going to argue that the evidence, that there's no possible way that all of the evidence taken together could possibly justify a verdict in your favor. And now, because of that, the defense lawyer is going to argue, listen, Judge, you have to throw this verdict out because there is no rational way for the jury to have come to this conclusion that this patient is entitled to a verdict in their favor. Simply none. The evidence does not support it. And now the judge has to make a decision. The judge has to decide whether or not that request is correct. Was the evidence sufficient? Did they go ahead and do what they were supposed to do? Did they rely on the testimony and the evidence presented? Or did they come to an off-the-wall decision having nothing to do with the evidence in this case? So what are some of the options that the judge has available? One option is the judge can immediately turn around and say, no, I'm denying your request, defense lawyer. Everything is going to stand as it is. If you don't like the decision, you go ahead and appeal it. A second option that the judge has is he could turn around and say to the defense lawyer, you know what, you're absolutely right. There's no basis, no rational basis upon which this jury could have come to this conclusion. I'm throwing the case out. And the injured patient's attorney, if you don't like that verdict, you can appeal it. So at the end of the case, at some point, one side or the other is going to be unhappy when the jury reaches a verdict. There's always going to be someone who wins the case and always going to be someone who does not win the case. And the person who does not win the case has the option of appealing that verdict. In fact, there are some instances where both sides will actually appeal the verdict. And I'll give you a quick example. One example would be where there's a verdict in the injured patient's favor, but the jury doesn't give the injured patient sufficient money, sufficient compensation to justify all of the injuries that they suffered. In that instance, the defense attorney may go ahead and say, listen, I'm going ahead and appealing the verdict because I don't believe that the patient should have gotten a verdict in their favor. And the injured patient's attorney goes ahead and says, you know what, I'm going ahead and appealing this verdict because there's no possible way the jury could have come to this conclusion and given this injured patient such a small amount of money. So that's where you see an instance where both sides would actually appeal. But where the defense lawyer says, listen, I want this verdict thrown out because it is against the weight of the evidence, it simply means that there is not sufficient evidence to justify this particular verdict. So the judge has another option still. He can go ahead and say, you know what, I'm going to withhold my decision, and in the interim, I want you, defense attorney, to go ahead and submit written papers to me. I want you to get the trial transcript and submit those portions of the testimony that you believe are favorable to you, that support your request. And then I'm going to give the patient's attorney, the plaintiff's attorney, in this case, Mr. Oginski, time to reply. And then I will go ahead and do my research, and after a period of time, I will reach a decision. And guess what? Whoever wins that part of the decision is going to be very happy. Whoever loses that decision, now they have the opportunity to go ahead and appeal. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I do recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.